Hello, everyone. I'm Erin Daly, and it's an honor to welcome you to the next panel of this conference. It's been such a privilege to play a part in this wonderful and eclectic conference. The presentations so far have not only been inspiring and galvanizing, but have reminded us of the critical moment that we are in and the enormous challenges facing us. These challenges are not only practical, what do we do in what forums and using what strategies with what alliances, but also conceptual. How do we even think about the relationship between human rights and climate change or global warming and biodiversity? Or more broadly, how do we think about the relationship between human rights and planetary health? How do we even put them together in one sentence or in one thought? This panel will help us work through these questions, starting from the perspective of human rights, and specifically the perspective of human dignity. Human dignity is recognized at all levels of law in scores of international human rights instruments and in regional human rights accords across the globe. It's the essence of the European Convention on Human Rights. It's the leitmotif of the Inter-American human rights system. And it's explicitly protected in more than 160 constitutions around the world. This means it's being applied in literally thousands of cases across the globe, touching on the full range of human experience and increasingly recognizing the importance to climate and environmental conditions, to the protection and enjoyment of human dignity. We can think about human dignity as having several essential aspects. Simply put, it represents the equal and inherent worth of every member of the human family in present and future generations. This means it gives rise to the full span of human rights, including civil and political rights like freedom of expression, voting rights, and rights of participation and association, as we'll hear, as well as social and economic and cultural rights like the rights to housing, health, education, water, and food, and yes, the right to a healthy environment. So it makes sense to launch this portion of the conference with a conversation that focuses on the relationship between human dignity and climate change. If we're going to protect the planet starting now, we need to do it in a way that embraces and understands the full meaning of human dignity. So to get the conversation going, let me introduce our speakers. Catherine Duprey is an associate professor of comparative constitutional law at the University of Exeter. She is the author of an extraordinary book documenting the place of dignity in European legal thinking called The Age of Dignity. She's currently at work on major projects trying to understand the relationship between dignity and such complex and broad-based issues as democracy, as well as dignity and time. This is not someone who shies away from difficult problems. So it seemed perfectly appropriate to invite her to speak with you about dignity and climate change. Marcus Duell is a moral philosopher working in the Netherlands. He's the main editor of the Cambridge Handbook on Human Dignity from Cambridge in 2013, and Towards the Ethics of a Green Future from Routledge in 2018. Between 2002 and 2020, he held a chair for philosophical ethics at Utrecht University, where he directed the university's Ethics Institute in the Netherlands School of Practical Philosophy. Marcus is one of our most insightful philosophers on the relationship between dignity, intergenerational equity, and ecological conditions in the context of contemporary transformations in general. Another perfect speaker to contribute to this conversation about dignity and climate change. Our last speaker, Dina Lupin Townsend, is a postdoctoral researcher in the philosophy department at the University of Vienna. She is also the deputy director of the Global Network of Human Rights and the Environment, where I have to say, forgive me for this plug, but she is organizing an upcoming week-long summer-winter school beginning January 21st, co-sponsored with UNEP. So if you want more information about that, you can contact Dina or me, or go on to the GNHRE's website. Dina's book, Human Dignity and the Adjudication of Environmental Rights, was published by Edward Elgar in 2020. Her current work takes a critical perspective on public participation, showing how socially marginalized groups suffer practices of silencing and epistemic injustice in their efforts to participate in decisions that affect them, including especially environmental decisions. So Dina will take a very critical perspective on the relationship between climate change, public participation, and the demands of human dignity. We will have time for questions after our guests have made their presentations, so please send your questions into the Q&A. Catherine, the floor is yours.
Thank you very much, Erin. So I will start with sharing my screen briefly. Yeah, so you can see. So this is the, so thank you. I would like to start by thanking the organizers to invite me to take part in this conference and for giving me the opportunity to take my first steps in the territory of climate change and future generations. That is, for me, a new territory. So my paper here is entitled Human Dignity, a useful tool for thinking human time and climate change. There's a question mark at the end of my title, but my answer is yes, I'm more positive than that. I will make 3 points and explore 3 points with you in the paper. First, I will elaborate a little bit on what Erin has said about human dignity, and I will explain what I understand by the dignity promise. And this understanding of the dignity promise can help, I think, understand or address 2 key questions that I think we are facing now. The first question is why we should consider future generations now and find ways of taking them on board with us. The current is a very difficult question. It's about who are the future generations, and this raises issues of identity, reciprocity, and I will explain briefly issues of democracy. My focus, as I said, is not, my specialism is not in the field of climate change or future generation, but I'm coming at this discussion from the perspective of human dignity, and you can see this is the cover of the book, which contains most of my ideas of human dignity. So I will stop sharing my screen now and start looking at and discussing the dignity promise with you. So a key point, and Erin said that, but I just want to build a little bit on what she said about human dignity, is that human dignity is not just, I think, a sort of beautiful philosophical concept and a political aspiration. It is also very much a legal concept. We have a whole body of dignity law, a very rich body of dignity law, and I think the work of Erin Daly and James May, who was the keynote speaker today, has been very important in bringing that dignity law body to light and for everybody to be able to be aware of it and to be able to use it better. Human dignity is, in fact, I think, the foundation of the whole human rights system, and being the foundation, I think it is also the ultimate aim of human rights and human rights protection. Human dignity is everywhere. It's at the UN level. It starts with the UDHR in 1948, or maybe just before, but I'll use the UDHR as my starting point. We find it in the regional level. Erin's mentioned some key text here, and my focus is very much on the European level of development of human dignity. And we find it in domestic systems, codified in constitutions, but as well, and perhaps above all, it has been really actively developed by judges all across the world and in ways that are quite similar, despite, the enormity of the case law. So in short, human dignity is a universal aspiration. I think all human beings across the world want to be treated and related to us with human dignity as human beings. And of course, we have to expect to treat everybody as human, with human dignity. And as such, I think it gives us a very useful common language, a common basis to talk to each other across all the differences that, make us unique. And it gives us particularly important, I think, a common language to share our concerns and our efforts to protect the environment, to address climate change, and to make space for future generations. But it is also a very powerful legal tool, and it gives us a very powerful and rich toolbox on which to draw to start and to keep working on improving and working towards climate change and environmental protection. So my starting point with human dignity is to consider human dignity as a promise, the dignity promise that was made, I think, in 1948. I use this text for because it's convenient, because it's the first text as well. I think it's perhaps the most inspirational and the most influential, but it isn't the only text that captures the dignity promise. And it is this promise that is made in 1948 that all human beings are born free and equal in dignity and in rights. And of course, we know in reality this is not the case. And it certainly wasn't the case in 1948. But it is the promise that we have to envision the world that lies ahead. We have to envision the future that lies ahead as a world in which this promise may be realized, and as we have to work towards that promise at all times. So this dignity promise, in my understanding, has two dimensions. One is the promise not to destroy humanity, and that has been a very, very important foundation of the post-war reconstruction of the world, and in particular the reconstruction of the world of law, human rights law, and the understanding of democracy. So it's the promise never again to use law or to make it possible, or that any legal system should make it possible for humanity to be destroyed in the way it was destroyed during the Second World War. And I think the declaration makes no reference to the Shoah or the Holocaust, but I think this is clearly one and perhaps the most traumatizing event. But it's not only that, is genocide is, as come out, so to efforts to prevent genocide, efforts to equip the law to prevent genocide. It hasn't always been successful, we know. The promise never again to destroy humanity has fed into the definition and the creation of crimes against humanity. So the promise not to destroy humanity is one side of the dignity promise, and it is perhaps a side that is fairly well known. What I want to develop with you is another dimension that may not be so well known, is what I call the time dimension of the dignity promise. So as it is a promise, and by definition, by being a promise, that presupposes a particular construction of time. A promise is imagining or positing that there will be a future. So now this is not the case, but I promise you this will happen. So by imagining the future, we also create a present. And I think in 1948, it was very, very important to create that present, because it was a present designed, quite deliberately designed by human rights instrument, to be a present moving away from the past. And the past, as the time was the past from which we wanted to move away, was the past of inhumanity, the past in which humanity had been destroyed, the past of the war, the past of the Shoah in particular. So the dignity promise creates a very particular temporality with which I think we are familiar without quite always fully understanding the significance or the implication of this promise. So a future, present, and a past that we want to compel ourselves to face, to address, to acknowledge, to learn from, and to move away from its most dehumanizing, dimension. So these three temporalities are key to understand human dignity, and I think they're key to understand the dynamic of the promise. They are separate temporalities, the past, the present, and the future, but they are also temporalities that are interconnected. interconnected, and they are so tightly interconnected, in my view, that it's difficult, if not impossible, to have one temporality without having the other. And I'll come to that in a second. So understanding human dignity as a promise is important, and it is, I think, what may help us address or begin to address two big questions about climate change. And I'm looking at climate change here from the perspective of future generation, because that's a good connection with humanity in my way. So the second point of my paper, which is the first question that the dignity promise may help us, we may use the dignity promise to understand, is why should we at all bother to protect future generation? Why should we protect generations that are in the future, we're in the present, and why does it matter? It's a big question, because I think it's also a question that is always put to environmentalists, and why should we do it? And so I think this, looking at the reasons, or looking at these questions from the perspective of human dignity, can give us some reasons, some hopefully good reasons, persuasive reasons. And I think we can look at this question from two approaches, from two perspectives that are complementary. We can look at this question from the perspective of future generation, and we can look at this question from the perspective of the current generation, that is us. So the element of the dignity promise that can help us, I think, answering this question, why we should be bothered, why we should seek to take on board future generations. The element of the dignity promise that can help us do that is the element of time. The dignity promise is the promise not to destroy humanity, but it is also, as part of that promise not to destroy humanity, what it also means, I think, is the promise not to destroy human time, not to destroy the time or quality of time within which humanity can flourish, a time within which humanity can be possible. And I think here we see the connections between time and humanity. So I think time becomes a dimension, an element, a component of humanity. Historically, as I said, it included humanity, people had very particular examples in mind, examples based on race, examples based on ethnicity. But I think humanity includes as well time, and includes the future. So you can see where I'm going, includes allowing for future humanity to be possible. And on the basis, and again, I can't claim as much expertise as people we've heard so far, but I think there's one thing that is fairly certain, is the one thing we know we are definitely giving to the future generation is waste. Is waste that is so toxic that it may well kill them. And it's waste, the toxicity of which is projected for such a long time ahead of us that certainly I cannot begin to imagine that level of temporality. And that is a level of temporality that is very difficult to imagine, very difficult to relate to, and hence the question of why should we bother at all with that? So the dignity promise not to destroy humanity includes, as a result of us knowing that we are handing over all this waste that may kill them, that certainly is toxic waste, and then will remain toxic so for generations to come, and as far as we can count. I think also includes a promise to them that we will try to give them the ways in which to learn from the mistakes that we made. So we will try, we have to it matters because we want them not to make, certainly I do, want not to make the same mistakes as we made. And we want them to be able to learn from our past mistakes. It's the sort of learning from disaster phrase that Habermas used. So we want the future generation to be able to do that, because we want future generations to have their own future and their own future generations. So that's really important, I think, to help imagining the temporal scale which we are facing. The time dimension and the dignity promise can also be imagined or reflected upon from the perspective of current generations, and maybe it is easier because it's about us, and the two are complementary. So my way of understanding that is to go back to this human time, the dignity time, the past, the present, and the future, and they are separate temporalities, they are distinctive features, but they are also interconnected temporalities. So the reason why, and I think to me that is a very compelling reason, the reason why we might want to protect the future generations, so the time of the future humanity, is of course because their future is affecting us, is affecting our time and the quality of our temporality. So let me try to elaborate a little bit on that. And I have to say, I'm going to be fairly simple and maybe a little bit crude. This is pretty much still work in progress, but my thinking goes like this. If we think a contrario, if we did not include the future generation in our thinking now, if we did not include the time for them to exist, I think this would put a very serious question mark for our current temporality. If there is no future, then this puts the present into question. It questions the very direction of time, the capacity of time to evolve from present towards the future, the dynamic of time. And again, expressing things in fairly simple terms, I think when time becomes static, I think we're in trouble. We're looking at, in phrasing sort of extreme terms, the destruction of time, and we have to think about what this may mean. But we are looking at things like detemporalization or maybe regression. So it's not good for us not to consider the future, because it will affect the quality of our current temporality. This also, I think, raises the question of how we might want to be remembered. So promise is based on dignity. Promise is very much based on an effort to remember, on the capacity to retain the memory, and an active memory and a critical memory. So rejecting or excluding future generation may also, I think, question our willingness, or the extent to which, or the ways in which we want to be remembered. And I think this is something to reflect on and for discussion, rather than a fully finished and elaborate argument. The third point and last point of my talk now is just to argue or to explore the ways in which this idea of the dignity promise and of human dignity more generally may help us identify or imagine, maybe imagine is a better word, who those future generations may be. And that may help relate to them and may help understand better why we should care about them now. And now this question, I know Marcus is going to elaborate on that after me. So, but I just want to say a few words and share my thoughts about this. So it's a very, very difficult question, this question of who the future generations are, because of course, by definition, we don't know. So we can think for the next generation, so the children, the grandchildren, maybe the great-grandchildren and great-great-grandchildren. But of course, I think the whole issue of the future generation is much bigger conceptually and over time. It is a really difficult issue to figure out. And in particular, I think it's difficult for law, because law is not equipped to operate on that long term. Law can deal more or less with one generation, two generations, backwards, forwards, but we're not equipped. We don't have the tools, we don't have the concept. So we are struggling even to imagine and let alone conceptualize who those generations may be. And I think here again, the dignity promise may help us imagine, and the idea of imagination is very important. I think it has to come first or together with efforts to conceptualize at the theoretical level, perhaps, or philosophical level. So imagination, I think, if you see it in fairly simple terms, we imagine the unknown on the basis of what we know. And my assumption here is that the future generation are going to be human. I think this is sort of underlying assumption, but I think it's an assumption that perhaps needs unraveling a little bit more. Certainly that those future generation will be sufficiently human for us to have a sense that we are sharing. We have some sense of humanity or shared humanity. I think that's something important to bear in mind. So we go back to the other dimension of the dignity promise, which is the promise of humanity, not to destroy humanity, to allow humanity to flourish at all time for everyone. And in that context and in that framework of the dignity promise, humanity includes much more than the bare life, the bare biological life or subsistence or existence. Of course, it is really, really important, and it starts with protecting life and biological existence of humanity, and dignity is being used, and we've heard papers today, to boost the right to life and to boost the right to a particular quality of life within a particular type of environment that promotes that quality of life. So this is not a small contribution that dignity can make. But what I want to bring to the discussion here is the idea of reciprocity. So it's the second dimension of the dignity promise, is humanity, and a humanity understood on the basis of reciprocity. And that idea of reciprocity is, of course, key to connect current generation with future generations. And the connection goes both ways. And the way I'm understanding it is a connection based on equality. So it is that concept of reciprocity that is, in a way, the foundation, has often used as the basis for justice, intergenerational justice in particular. But what I want to do in the time I have left, checking my time, is to take that idea back to Kant. He's the philosopher who has perhaps most influentially, certainly for lawyers, shaped human dignity, and in his understanding of human dignity, reciprocity plays a very key role. It's the idea that you should always treat a fellow human being in the way in which you expect to be treated. Is the prohibition to instrumentalize fellow human beings and to reduce them to a means to your own ends. Is the reciprocity that you should leave to fellow human beings the freedom and the capacity to set their own ends in the same way as you wish yourself to set your own ends. And I think this idea, of course, Kant thought about it more in sort of intra-generational in terms of how the society should operate, more or less. But I think this idea of reciprocity applies across time and across current generation and future generations. So the way in which I think we can use dignity to imagine future generations is to imagine them as humans, to imagine them as human beings that are able, or that we want them to be able to set their own ends in the same way as we have given ourselves the rights and the power and the freedom to set our own ends, and to set, we want them to be able to set their own ends together. And that brings democracy into the discussion. So it's a particular understanding of humanity that can flourish in a particular broader framework, institutional framework of democracy. And I know Dina will say more about this in her paper. So that is the type of humanity that future generations can be imagined as having, or that we can will or wish them to have. So in conclusion, human dignity can help us address the questions as to why we should bother at all to protect and to take on board the existence or the presumed existence of future generations now. It helps us, I think, greatly to imagine better who those future generations can be or should be like us, but how, in which conditions, human beings who are able to self-determine. And that capacity to self-determine is really, really important, not just in the concept of democracy, but of course, what is really important that they should be able to do, those future generations, is to keep protecting the planet and the environment in which they live, because this will not stop with our generation. And how this should be done, well, this can be done, and this is really not for me to go over that, but we've seen very clearly, we've heard discussions and papers before how this should be done, and this should be done quite clearly now, and that is prompting us, in addition to the talks we've heard today so far, to reflect on what is our humanity, how we understand humanity, and how we understand, democracy, how we want to keep shaping the democratic framework in which hopefully the future generations can happen. That is the end of my paper. Thank you very much for listening.
Thank you so much, Catherine. That was fantastic. Yes, thank you very much. Raised a lot of really interesting and difficult questions, and I'm sure we'll hear more on some of these things from Marcus. So Marcus, the floor is yours. Thank you.
Okay, can you see my screen? Okay. Yes, I'm more or less directly following on where Catherine ends. It's it's more or less the same story in a different variation, so to speak. So what we have to be aware of is that the story to which Catherine already referred, namely the start of the entire human rights, human dignity discourse, is a discourse which took its starting point at the Shoah at the end of World War II. And what people had in mind at that time was the condemnation of extreme forms of instrumentalization of human beings. But at the same time, human dignity functions in the human rights regime as the foundational concept. And I think that is from importance, because we cannot think about human dignity as an isolated concept. Yeah, you always, if you say human dignity, you directly say, you speak about the entirety of what human rights are about. And that means legitimation and limitation of governmental power. So on the one hand, you say there have to be governmental power in order to enforce rights in the first place, or to be able to have some kind of rights enforcement. And at the same time, the way governmental power can be exercised is limited. It's limited, and at the same time, it's qualified. And that means if you say you are committed to human rights, you are committed to rule of law. And I personally prefer the German term Rechtsstaat to be sure. So the state of, it's not just a rule, it's the way government is organized. It's organized according to law. That says Rechtsstaat, state of law. Democracy. So in the moment where we respect each other as equals, this means we have a say regarding the governmental power. We legitimize it. And at the same time, it cannot be reduced just to one state. It always have an international dimension. But that international dimension does not mean a commitment to a world state, but it means that governmental power has to be exercised in a way that peaceful coexistence of states is possible, and that human rights protection elsewhere is possible as well. Now, and at the same time, these human rights commitments have normative priority. And this meaning normative priority implies whatever else, whatever kind of considerations we are thinking about, which will guide our actions, human rights commitments have some kind of priority. That is meant if we say human dignity, so to speak. Now, this directly leads to a problem. If human rights are in that sense overriding, if they have normative priority, and if human rights imply liberty rights, and if these liberty rights within a human rights regime can only be limited by other human rights duties, then we are in the situation that either future generations are part of this regime, so that it's legitimate by the interest of future generation to limit our liberties, or human rights commitments were forcing us to ignore future generations. Yeah. So we cannot rationally say we are committed to human rights are overriding, but future generations have nothing to do with this game of human rights, and nevertheless we care for them. So if our liberties come first, then we should ignore future generations unless future generations are part of this regime protected by human rights commitments. And that is particularly important since some aspects of our liberty rights are one of the sources of the endangering of future people, namely our right to travel, our right to exercise all kinds of freedoms, our right to reproduce unlimited, and so on. So to some extent, the exercise of our liberty rights is one of the reasons, or perhaps the main reason, why future generations are endangered. So, of course, I'm aware that the rights of the younger generation imply some rights they will exercise on a later stage. Yeah, so it's not just about future generations, would imply those people who are not born yet. There are as well aspects of protection of the younger generation who will exercise some rights in the second half of the century, and this exercise is endangered by current action. But nevertheless, that cannot be the entire story. And that's what Catherine already referred to, because we are not just talking about today and the next generation and the grandchildren. We are talking about the future in a much broader scale. And it's quite likely that there are some aspects where the long-term protection of humanity is not covered by the interest of the younger generations. So, and this entire story is much more difficult, so to speak, because it's very more plausible to assume that we can do something with regard to climate change in a long-term perspective and in a preventive perspective. But our possibilities to do something against it in the moment where the problems are manifest is much more limited. So we have to act in a situation where the human rights violations, so to speak, are not manifest yet. And there is a problem because I think the way we organized the human rights regime in the past is characterized by a presentistic bias. So we are very much concerned about human rights violations in the moment where they occur. We are less concerned in the moment where we can, where there are foreseeable human rights violations in the future. Now, that forces us to think about a reconstruction of human dignity, and so a much more theoretical reconstruction. And I would go in the following direction. I would think we should understand human dignity as a pre-legal reason to shape a normative order on the basis of respect for all human beings, so that it's a kind of moral commitment, but it's a moral commitment that forces us to realize something in the legal domain, and that this commitment to human dignity is based on nothing else than a consistent way of understanding ourselves as human beings. Human rights, I understand as entitlements to enjoy liberties. So these, and so entitlements for everybody. And now the relevant point is that these human rights commitments means that we see everybody entitled to enjoy those liberties, that this view on human beings creates something which one could call a community of rights. So that means the entire idea of seeing us as beings worth of respect, this entire view is creating something like a community. And that is fundamental. So it's not that we should understand human rights just only as entitlements. It's not just about us being entitled to do something, but it's a specific view to create an entire normative order based on this respect. And if one says we are committed to respect for human beings, then I think this implies their duty to protect those goods, those means necessary for human beings to live an autonomous life. So the respect is realized in a specific form of protection of the necessary goods that human beings need in order to live their own life. And the possibility that collective goods come into the picture as they are relevant for the climate change debate has to do with the fact that some of these goods, or the most basic of these goods, are generic goods. That means goods that are not just goods I need to live my life, but everybody needs to live autonomously. So that means life, security, ecological stability, some form of peace, and so on. There is a variety of goods that are necessary for everybody to live in their own life. And I would say that human dignity as well implies some idea of hierarchization, so that not all these goods are on the same level of importance. And certainly something like ecological stability belongs to the most fundamental generic goods you can think about. Now, here's my argument why future generations are relevant in this game. So if we think that human dignity obliges us to protect the goods necessary for human beings to be able to live an autonomous life, then we need those considerations in order to think that future generations are part of it. So we have to assume that there will be human beings in the future. So if we could be certain that that will end soon, the entire topic will disappear. We have to assume that future people will share basic features with us. That's something Catherine already referred to. So we have to think that they, even though they may be different in all kinds of respect, perhaps they don't like religion anymore, perhaps they don't drink single malt whiskey, perhaps they have other strange ideas, but nevertheless they will have a body, they will have some kind of psychological problems, they will depend on some kind of ecological environment like we do, and so on. So if we wouldn't share anything like that with them, we could not even know in which regard we could endanger their liberties. And the third point is we have to assume that our actions have impact on their life circumstances. If that wouldn't be the case, then the entire topic would disappear. And I think all of that is enough to say we have human rights duties with regard to future people. And that these conditions are not depending on the fact that they are already there. So yeah, so the simple fact that we are able to imagine a future where human beings will be similar to us, and where we have to assume that our actions are impacting their life circumstances, that is enough to assume that human rights commitments forces us to take these considerations into account. Now, that is very fundamental, but it has a variety of implications, and I only want to mention some. So I think this entire story makes us aware that human dignity is not based on an atomistic view on human beings. Yeah, so it's the entire idea of seeing each other worthy of respect is already a kind of creating a specific form of relationality, which should guide our view on what society is in the first place. And in the second point, I would say it forces us to create political powers that are enabled to enforce these rights. And this latter point is much more difficult in times of climate change, because we are aware that enforcing the rights of future generations is not a story Luxembourg can in a meaningful sense do by itself. And not even Germany, the US, and so on can do it by itself. So there has to be political actors, but as well international organizations that are capable of doing these rights enforcements. And that, from my point of view, have impact on the way we can think about and have to think about political organizations. But it as well, and that goes now much further, has implications for the way we interpret the world in general. And here I have a link to what Catherine already said. It has something to do with our view on history and our view on time. So we have to think, in my terms, point of view, the future is open. So in the way Catherine said it, if it's important for us to be able to set our goals, it must be for future people as well. But that already presupposes that there is some future orientation in which it is meaningful to set goals. And yeah, that's something we cannot know. We cannot have no knowledge about the future, but I think that the concept of hope comes into the picture. And I think we have some discussions now at the moment about moral progress. And I'm not such a fan of progress because it implies some knowledge about history, but I would think that hope is a much more fruitful notion here because it helps us to think about the future in terms that leave room for those things that are protected by the human rights regime. A last comment in terms of law. So if you say rights of future people, that directly brings courts into the picture. And that is relevant. So in the Netherlands, we had the Ogenda case, and we had just a court judge that Shell has to do much more in terms of sustainability. And that raises a lot of questions. To what extent now politics is made by judges, by courts? And I don't think that emphasizing rights of future people should be a reason to reduce the entire story to a legal enterprise. So I think laws should, judges should play a much bigger role in the story. So, for example, the German highest court some weeks ago decided that the foreseeable liberty infringements in the 2030s shouldn't be too big. So the state would have to do something now in order to prevent that in the future foreseeable liberty infringements are disproportional. Yeah. So the courts, in my view, can say something about these constraints under which politics works, but I don't think that it's eo ipso evidence that rights of future people means that now the courts should do the job of politics that would be fundamentally problematic in democratic terms. So I just say that in terms of a disclaimer, because I think everything I said, and it's very much in line with what Catherine said, is a reason to take future people into consideration. But the question how to do that and which role courts should play in this regard is a very specific topic from which I don't think it's answered already by the things I said so far. Thanks a lot.
Thank you very, very much, Marcus. That was incredible and so thought-provoking. I mean, the two of you together have just raised so many very big and difficult questions that we really want to think about more. Next, we're going to hear from Dina, who I think is going to contextualize some of these things and specifically invite us to think more about how these big ideas of dignity and ecological conservation and protection from the impacts of climate change operate in the context of political participation. So thank you, Dina.
Thanks very much. Thanks to Erin and Stephen for inviting me to this fantastic event. My talk is going to be a little different, slightly different focus, but I think it kind of builds in some ways. I'm going to be talking about climate change in the context of dignity, participation, and resistance. So, participation, particularly in, let me just check, can you all see my slides? You're looking at a group of men.
Yes.
Okay, great. Participation, particularly in the form of consultation, has come to play a major role in environmental law and rights, and an equally important role in climate change law and in the development of international climate change agreements. So the United Nations Framework Convention on Climate Change, so kind of from the very beginning of international law on climate change, encouraged states to ensure education, training, and public awareness related to climate change, and the widest participation. And participation has remained a critical theme in the evolution of the international agreements, but also at domestic level in the development and implementation of various mitigation and adaptation programs. And the basic principle that people often express in relation to participation is that participation ensures inclusive decision-making, it ensures better informed decisions, it ensures more legitimate decisions, and importantly, for the purposes of climate change, it secures better social buy-in, which can be very important when what you need is broad social change, broad changes in social behavior. But to my mind, participation is also important because it secures a more kind of fundamental function, which is that it is an expression and respect of human dignity. Dignity is connected, as I understand it, to the capacity and authority of people to give an account of themselves and their stories. One of the most obvious ways in which this comes up in court contexts is through due process requirements, which allow those affected to present arguments, give evidence, and other kinds of submissions. And the law requires that the parties are listened to and that their claims are taken seriously and attended to carefully in the reasoning of the court. So human dignity has been connected to the idea of self-actualization and self-determination. Courts have interpreted dignity to emphasize the importance of having the content of our deepest and most important choices recognized as valid. In cases, for example, on rights to same-sex marriage and on rights to live in a gender not assigned at birth, courts have found that dignity demands respect for the claim of what one is, to assert one's identity, and to have those claims listened to, respected, and taken seriously. Dignity recognizes people in this context as authoritative in respect of their own selves, and in their individual, collective, social, cultural, sexual, embodied identities. But while participation is commonly seen as crucial to ensure sound, legitimate, informed, and socially acceptable climate change decision-making, participation also, when done properly, seems to serve this more fundamental dignity requirement of allowing people to express themselves, their interests, and to account for the ways in which environmental decisions, climate change decisions, may shape and change their lives, may shape and change their identities and their sense of self. Equally, denying people the opportunity to participate silences their voices and is a profound disrespect of dignity, and those who are not consulted and are not allowed to participate in decisions that affect them often express their feelings of being disrespected and devalued, not only that their input is not taken to matter, but that their experiences and they themselves are not taken to matter. Consultation processes, however, have increasingly become the only way for communities to engage in the decisions that are being made about their environments. Participation is, in many cases, not an aspect of a climate change right or an environmental right for marginalized groups, but the entirety of those rights. Community rights to land, to a healthy environment, to family life, all end up being subject to negotiation, and securing them often means negotiating for them in participation processes. Likewise, proposing alternatives, engaging in co-production, benefit sharing, all of these demand a participatory process, one in which those affected are called to the table, as it were, to give an account of themselves. As a result, participatory and consultative approaches don't just create the space for people to give, to assert themselves and tell their stories, but may in fact compel them to do so, force them to give an account of themselves, and that this in itself can be a degrading violation of dignity. This is especially the case in the context that I work in, that I'm interested in, namely consultation with Indigenous and marginalized and rural communities. Just a side note before we go on, the photos that you are seeing, the photos that have been in the previous slides and in this one, all are from consultation processes that I and my clients participated in when I was an attorney working at the Centre for Environmental Rights in Cape Town. And this picture is a picture of, it's a still from a film featuring Thelma Nkosi, who's an activist from Mpumalanga. And in the film, she describes her years-long battle to get the mining company, who she woke up one morning and there was an anthracite mine on her doorstep, to get them to talk to the community and, as she puts it, talk in one voice. One problem that communities encounter is that consultation processes are notorious for failing to actually ensure people an opportunity to have a say. Sorry. In RED plus preparedness processes in Uganda and Nigeria, in Kenya, in climate change information programs in the Congo, in mining license decisions in South Africa, consultation processes fail communities. In my years as an attorney representing mining affected communities, my clients and I directly experienced or witnessed the following practices. Mining companies only consulted, by which I mean bribed, traditional leaders. They refused to provide information to or only provided information in accessible locations to communities. They only provided information in languages communities did not speak. They provided false information about the nature of the consultations to the communities and about the outcome of the consultations to the decision makers. They only allowed men to speak. They only allowed the elderly to speak. They didn't allow anyone to speak except themselves. They falsified documents. They falsified signatures. They sent in the police to kill and terrorize community members. They pitted community groups against each other. They set houses on fire in the night. In the picture, you see on the right-hand side, Sikosipo Bazuka Radebe, a human rights defender, and on the left, Mam Fikile in Shangasi. These are both environmental human rights defenders who've been murdered, and no arrests have been made in relation to either of their cases. These practices in denying communities an opportunity to participate and have their say clearly demean the dignity of all involved. But often it's claimed that these failures are the result of bad and greedy men or poor enforcement oversight by officials. The idea is often expressed that were we to simply design better processes supported by the resources required with stronger safeguards, better implementation, were we to simply wrest consultation out of the hands of the greedy, then meaningful, dignity-centered participation would be possible. And it would give affected communities a platform to have their say. But I'm increasingly of the view that even in the best of circumstances, in a fully informed, timeous, fair, free participation process, all participation processes are plagued by problems that cannot be simply regulated away. This is because understandings of participation tend to overlook the extent to which consultation is a social act, one that does not only require creating a platform for affected communities to speak, but also requires that the audience hears them and hears them as they intend to be heard. Both the speakers and the listeners have a critical role to play in participation. But lack of common modes of communicating, lack of common hermeneutical and conceptual resources, and listeners without the capacity to hear speakers tend to get in the way, resulting in practices of epistemic exploitation and silencing. I'm going to have a look at each of these concerns briefly. First, consultation tends to assume we speak to each other in the same way, and that if the affected community has a platform, the consulter will be able to hear them. But we don't speak in the same way. And often the ways affected communities speak are not easily translatable into the language of negotiations or consultations. Take, for example, on the slide here, you're looking at Bonakile Mtwa. She's a member of the Amadiba community. And in a video interview with her, she talks about an engagement she had with a group from the city. And one of the things she says is that she realized through this engagement that she had a problem communicating because she says, I love to speak, but I love to pass the message by singing traditional songs. And at some point in the engagement, she comes to realize that others don't understand what she's saying when she sings. And so she has to change the way she communicates, she has to speak. Another example of different modes of speaking we see in a submission made by the Kuararig Aboriginal First Nations people to the UN Economic and Social Rights Council. In that submission, they describe their experience of the state's efforts to obtain consent by covert means, including by failing to listen to the way this community speaks through silence. Our known cultural norms of silence, they write, are interpreted by non-native rules of debate and majority votes, duly registered as our agreement. Despite our cultural norms of silence being well known to the social sciences, where our silence indicates respect and disagreement or discomfort, our silence is turned against us and used to indicate our consent. In addition to speaking in different ways, parties often do not share the necessary hermeneutical resources to understand each other. The consultants lack the concepts the consulted use to describe and make sense of their experiences. And at the same time, they impose their own conceptual framework through the consultation process. So Carl J. White, who's an indigenous philosopher from the States, who's pictured there, has argued that concepts such as climate crisis and Anthropocene have been foisted onto indigenous peoples without their participation or agreement, and that the ideological and temporal frames that these concepts suggest make little sense to indigenous peoples. White argues that climate change is not some new crisis, but the continuation of a crisis that is ongoing since colonization, under which indigenous peoples face environmental destruction, land dispossession, forced relocation, and the ending of their relationships to plants, animals, and entire ecosystems. Climate change simply promises then more of the same. But so do REDD+ programs, and alternative energy projects. These are yet more modes of authority and regulation that prevent indigenous peoples from living on and with their land, resulting again in forced removals and the ending of relationships with plants and animals. From that point of view, REDD+ and renewable energy projects, climate change and colonization are the same. The idea of crisis and of solution are not common then between indigenous peoples and climate change policymakers. The Kuararig, that's their symbol in the second box on the screen there, also point to conceptual gaps, highlighting the fact that consent has no equivalent word in their language. In their submission, they pick the word apart by examining its etymology, going back to the 11th and 13th centuries, looking at the French and German roots of consent, revealing not only the awkwardness of forcing people to fit their self-expression into foreign concepts and terms, but also the hidden historical meanings of notions of consultation and consent in English. So differing ideas of crisis and solution, and I don't speak about it here, but very differing ideas of time and temporality are not just conceptual misunderstandings between consulters and the consulted, but rather I think the consulters lack the hermeneutic resources with which to make sense of indigenous experience. In addition to lacking modes of speaking and common hermeneutical resources with which to make sense of the world, Audiences also often suffer from a kind of ignorance that inhibits meaningful listening. A few years ago, I attended a talk at the University of Oslo, where I was based at the time, on the topic of free prior consultation. And this talk was attended by a number of CEOs of Norwegian hydropower companies. Norway is a major funder of renewable energy abroad, and many of the companies responsible for developing renewable power projects all over the world, but especially in Latin America, are registered in Norway. So the speaker who's giving the presentation described the legal requirements for consultation, and as he did so, one of the CEOs raised an agitated hand, and he said, "We try to consult, but the problem is that they don't see that this development is for their own good." In believing that damming up a river on Indigenous land is for their own good, the CEO displays a profound lack of awareness of the temporal and emplaced conditions in which many Indigenous communities live. In his mission to save Indigenous peoples from themselves, he's no concept of the way in which the affected communities might understand their own histories or their environments, or even the climate crisis that he thinks justifies radically transforming their lives and territories. All too often, Indigenous peoples find themselves having to explain and often evidence their own oppression and experience to those whose ignorance prevents proper consultation. As a result, these communities are required to undertake an unpaid, often unnoticed, emotionally taxing kind of coerced epistemic labor. As Audre Lorde, who's in the top right corner there, put it, Black and third world people are expected to educate white people as to our humanity. The oppressors maintain their position and evade their responsibility for their own actions. Affected communities are exposed to practices of what Nora Berenstain, she's in the bottom left there, has called epistemic exploitation. Berenstain argues that this draining and unpaid epistemic labor centers the needs and desires of dominant groups and exploits the emotional and cognitive labor of members of marginalized groups who are required to do the unpaid and often unacknowledged work of providing information and resources. Having to explain one's oppression and to often skeptical outsiders is also a violation of dignity in these contexts. Rather than being given a space to tell one's story and account for oneself, Indigenous communities are compelled to do so, forced to expose themselves in hostile consultation processes with ignorant audiences. Addressing the ignorance of audiences is often an essential first step for any engagement or conversation to take place, but consultation processes rarely make time or room for teaching ignorant outsiders about the conditions of oppression of Indigenous groups. So, for example, in compliance with the UNFCCC's enhanced Lima work program on gender, which is really kind of the key gender program in the climate change matrix of international law, various climate change information services projects have sought to ensure gender mainstreaming by improving consultation with women. But none of the programs I have examined include anything that addresses the ways in which consultants gender the communities they are consulting. Getting consultants to see, for example, beyond their own binary set of practices of gendering to consider the experiences of the targeted community is not an explicit goal mentioned in any of the project documents I have looked at, or in fact in the enhanced Lima work program. Demanding that speakers account for themselves to ignorant, unsympathetic audiences who have no obligation to listen not only results in epistemic exploitation, but may also result in a kind of coerced silencing or distorting of the speech of the affected community. Christy Dodson, who we can see in the background there, sorry, I haven't explained my funny little table. I've just talked about kind of the first leg, communities become teachers, but this results in epistemic injustice, but they encounter no obligation to learn from their hearers, and now they experience this phenomenon that Christy Dodson talks about. She argues that a hearer's persistent and robust failure to understand the speaker's perspective and social experience renders the hearer incompetent to properly comprehend the prophet's speech. And this means that the speaker does not speak at all or distorts their claims to only address that which the audience has demonstrated competence for. In my own experience, I regularly watched communities reduce their arguments to haggling over details of a mining operation, or agreed to leave out discussion of apartheid or spatial injustice because mining representatives failed to recognize its relevance and felt it did not move the conversation forward. Perhaps most importantly, participation processes with Indigenous and marginalized groups, even well-designed processes, are in many cases calling on these communities to participate in decisions relating to REDD+ programs or hydro dams or extractive energy projects that will result to some degree or another in the destruction of their land, their communities, their culture, their lifestyles, and their livelihoods. That this is the context in which they must participate should not be forgotten. No matter how committed, involved, open-minded the people on the other side of the table are, they're not participating in a discussion or negotiation about their own destruction. This context of threat and history is not only critical to understand the real pressure under which affected communities participate in these processes, but it's also important to understand the extraordinary hurdles that communities must get over in order to begin to engage with antagonistic or ignorant outsiders. While dignity demands that people be given the space and opportunity to assert their sense of self and tell their own stories, there's nothing dignified about obliging people to tell their stories, sometimes again and again, in contexts in which they face their own demise. Given the enormity of the impact of these decisions and the long history of oppression and exclusion Indigenous groups have suffered, Indigenous peoples have demanded the right not only to consultation, but to consent. And consent, or more specifically, the right to say no, does seem to address the problems I raise here. It allows communities to assert their identities by creating the opportunity to say no. And since no is all that's required to refuse consent, as it is normally understood, communities are not compelled to tell their stories or to educate ignorant outsiders. The right to withhold consent seems to me to do more to protect dignity than participatory consultation processes do. But consent has not been defined in this way as a right to say no by states who rather envision the giving of consent, saying yes, as the ideal outcome of consultation processes, and have refused to acknowledge that consent gives communities any kind of right to say no, a veto power. In any case, as the Kuarareg Aboriginal First Nations peoples have argued, consent is not possible when Indigenous peoples are living in a governance system and under an authority they never agreed to. Since the Kuarareg did not consent to the current Australian governance framework that has been imposed on their lives in disregard of their own governance systems, they argue that they see no possibility for consent to new developments or climate projects within that framework. So, instead of participation as consultation or some watered-down version of consent, I propose that what dignity demands is greater recognition of participation as resistance. Communities across the world engage in participation through resistance, using protest and online campaigns, barricades, property destruction, slogans. Communities attend consultation meetings but refuse to enter the room, instead singing and protesting outside, or refusing to sign attendance registers, or even violently evicting consultants from meeting rooms or community land. Communities recognize the ways in which their stories and their participation have been used against them, and so they refuse to participate in ways they believe to be open to abuse. Thus, they are asserting themselves in two ways: by expressing their objections through protest, and at the same time by refusing to occupy the small and ungiving space of consultation that compels them to express themselves in particular ways. That these acts of resistance communicate a position in regard to a planned project on their land is indisputable, but they're rarely treated as participation. If anything, acts of resistance are more often taken as forms of non-participation, as in, we tried to talk to the community, but they refused to talk to us, so we can't consult them. But these are active participation and controlled by the affected groups themselves. And as such, these can be means to better realize dignity than the processes of participation that compel communities to tell their stories again and again to an unhearing audience. Because creating opportunities for people to assert their own identities means little when they have little reason to think their audience will hear them. I think this tells us something not only about participation and its failings, but also about dignity and its demands. While I still understand dignity is concerned with the capacity and authority of people to give an account of themselves, obliging them to do so does not protect or recognize their dignity. Listening when they do so, in protest, or in song, or in silence, is what is called for, and this requires recognition of resistance and not more forced consultation. Thank you.
Thank you so much, Dina. Another really riveting conversation that really puts some of the big ideas that Marcus and Catherine have been talking about and sort of positioning us to think about in the context of very specific and difficult controversies and situations. So I think that all three of these accounts of trying to come to terms with the relationship between dignity and climate change and the challenges of climate change have really raised a lot of difficult questions. I'm just struck. I just want to say one quick thing, and then if people are willing to stay for a few more minutes, we can maybe take a question or two. But I just want to sort of note that although these three presentations were really so diverse in their orientation and their focus, they all said something that was kind of interesting about the nature of human dignity itself. Catherine said that it's really ultimately about how we construct our humanity. How are we as a species going to construct what it means to be human? And Marcus said that it's really our self-understanding as human beings. So still sort of talking about humanity, but also talking about this personal notion of our own self-understanding, either on a species scale or on an individual scale, and then combining that with what Dina was saying about how it's really about the ability to give an account of oneself and of one's stories. That is the ability to create oneself, to make up that account and that narrative, and then to give it in a way that people will hear it. And I think all these are really sort of variations on a particular aspect of human dignity that is really very strongly connected to the challenges that we face in terms of climate change. We have a question from the audience, which I will read, and then I would also, if like to ask another question, and they might be connected. So I'm going to pose both. Thank you for an interesting panel. For each of the panelists, this anonymous attendee asks, what unique opportunities does dignity under law, so not dignity as a norm or as a value necessarily, but as reflected in law, what unique opportunities does dignity under law provide to address climate change? In other words, if dignity as a legal matter didn't exist, would it matter for global warming, for enforcement, for adaptation, and for mitigation? What is the argument, in other words, that arguing in favor of dignity is worth it rather than pursuing other legal means? So I would invite you to think about that question, really sort of what does it add to the conversation that people are having around the globe about how to deal with climate change? What does it add to that conversation to think about the legal significance of dignity? And I guess my question was sort of a slight variation, or putting that in a particular context, was just to bring in the concept of justice. And by justice here, I mean climate justice, water justice, environmental justice, and specifically the fact that so many of these impacts, as Dina's presentation implicitly said, but that so many of the impacts of climate change are not equitably distributed, right? People are feeling the impacts of climate change in very different ways, depending on sort of their status at the beginning. So I wonder in that context also, sort of to add to the anonymous attendees question, I wonder how dignity might help us think about climate justice. So nothing much to think about after you've all spent all that time explaining your thoughts. But if anybody would like to sort of jump in on the question, Marcus, let's turn to you first.
Yeah, perhaps I think, of course, it's not human dignity as a notion in the law that brings climate change into the legal debate, but there is at least one point. So it is not possible in terms of human dignity to realize sustainability in a way in which you totally ignore the views of the people. I think what Dina just presented to us is a bit the emphasis that you cannot protect the climate against the people, so to speak. So you cannot do that if you're committed to human dignity just in terms of economic measures and totally ignoring how people can relate to it. And human dignity so framing the problem in terms of human dignity means that we will, in one way or the other, have to take into account how people can relate to that. And I think that's an important aspect.
Yeah, thank you very much. I think that's absolutely right. Catherine, what are your thoughts on this?
Yeah, thank you. And I would like to thank my fellow panelists for their great talks, very, very inspiring talks. I think I'd like to come back to the points made by Dina, because I think when we think about human dignity, we often think of it as connected, and it is the foundation of human rights, like substantive rights, and a number of rights, and always greater number of rights. But I think it's important to bear in mind also that what dignity does, or sort of requires us to do as part of this wider promise, and that the way I see it is to create effective frameworks for communication. And I think it is, in my understanding, it is not by chance that often the dignity stories or the dignity disputes end up in courts. And although it's incredibly difficult to access courts, I mean, let's not delude ourselves. It's very, very difficult. And I live in the UK, which is, the sort of the queen of common law country, and all of that. Very difficult to access courts, and it's particularly difficult to access courts for those allegedly victims of human dignity, so that they have to overcome these incredible hurdles to access courts. But courts have remained the one established institutions in democracy, the one forum for those dignity stories to be told. And we have in courts, and it's by no means a perfect situation, because I fully take on board the points made by Dina. But why is dignity picked up more by courts than by politicians? Why is dignity case law advancing dignity more than statute law? And I think it is many reasons, but one reason may well be is that in courts we have this quite unique situation of a face-to-face of human beings. There's a judge who has a training, who should be trained, and that raises a whole range of questions about judicial training, to listen to the other person who should be seen as a fellow human being. So, and it's a unique opportunity for that person, the claimant, the petitioner, to tell their story directly to the judge, a story that is not mediated by politics and political interests and other interests, as it may be through the route of parliament. So this is courts. This is what dignity triggers. It requires to put those fora in place, and courts are one, but the process of consultation is another one, and it also requires us to check that those processes work and that they don't backfire in the terrible ways that Dina has said. And I think it would require as well, in that telling of the story, of course, the story can only be told if there's someone listening to it. And I think that for me, raises questions about how we train judges, for instance, how we organize hearings, how we train those people who go out and just consult with the local people and come back with their, whatever spreadsheet, and how the questions are put and all of that. So it does require that procedural dimension of human dignity, and that it requires that those procedural mechanisms be very firmly embedded in law. So given some kind of strong normative basis, they be given resources to function effectively, and they be regularly monitored to assess whether they function well. So I think that's what dignity, one difference that dignity can make. Thank you.
Thanks so much, Catherine. Dina, anything you'd like to add to this?
I mean, I agree with Marcus and Catherine, so I will add something, but I'll probably just be re-saying the things they said less well. But I think that, I think that when I first got interested in dignity, I was standing actually with Thelma and Corsi, whose picture's in my presentation. I was standing on the edge of a mine, this newly created mine, and Thelma kind of gestured towards the mine, and she said to me, look what they've done. They've taken away our land. They've taken away our dignity. And that was sort of critical moment in my thinking. And I think, I can't speak for Thelma, obviously, but dignity has such a kind of strong role in the sort of post-apartheid South African legal system. It's such an important concept in our constitution that I think what Thelma did, or what I kind of heard her doing, was both placing kind of her own humanity in relationship to this mine, but also placing her own humanity in law. And I think what human dignity does maybe better than any other sort of concept or value that we find in our legal systems. And I think Catherine's totally right that courts have really kind of made a lot out of this, is that it creates space for thinking about what it is to be human, creates space for thinking about our humanity. And as we face a kind of fundamental and existential crisis like climate change, thinking about what our humanity is critical, as is apparent in both Marcus's and Catherine's talks, thinking about our humanity not only kind of now, but in the future, and kind of in relation to the past, is also very important. And I don't think you can do that with notions of freedom and equality, but I think you are required to do that with an idea of dignity. And I think that Catherine's absolutely right, that it's a kind of tool that courts have used incredibly in some cases. Sometimes people are quite critical of the way it gets used, but what they've done often is kind of sort of read into and imbued the law with sort of meaning and significance so that it can respond to the moment that it's in, so that it can flex and react, and we can pull it out of 1948 and apply it to new notions of marriage or gender, or what it is to live, or what it is to work, and new understandings of who we are in relationship to our kind of ever more vulnerable environment. So I think it does a lot.
The short answer is a lot. Thanks very much. Obviously, there's a lot more to say about this. We are almost out of time, but I think we have time for one more question. And as it happens, we have one more questioner. So let me turn it over to Stephen Turner, who would like to ask a question, the panelists.
Okay, hi. Thank you to each of you for such a fascinating expose of dignity within this field and outside of this field. And for me, as somebody that has studied the field of human rights, the environment for a while, it's been really interesting to to be introduced, I have to confess, to this probably really properly for the first time. And so in studying this area and researching the area of particularly the relationship between human rights and the environment, what you tend to note traditionally in the literature is that there are plenty of references to the relationship between the environment and the right to life, plenty of references to the right to health and the relationship with the environment. And then, as we've already heard in other discussions earlier on today, related to housing and other areas too. And traditionally in the literature, there isn't so much, in my experience at least, reference to dignity. And I wonder why it is we've missed this. I wonder why it is that it's taken the initiatives that, that Erin has undertaken, that you're undertaking yourselves, for this to take so long to really come to prominence. And I should mention Jimmy, of course, as well. And I just wonder if you have a take on that, and if this is also representative of something that's happening within the human rights field generally, that this is happening. So that's my question.
Your thoughts, Dina?
I don't know if I've got a great answer for you, but when I first started working on my thesis, which was on human dignity and environmental rights, and at that point, kind of before I'd found the small community of us doing this, I felt very much alone. I presented my work to a group of human rights and environment specialists, and they said, we really don't need this. We have so many concepts. We don't need another one. We already don't know what sustainability means. We already can't agree on what environmental justice means. We don't need more. And I think dignity sort of carries that burden maybe more than other concepts. People find it to sort of open and vague and unpromising in its kind of ability to do everything and nothing. But I think, I argue at length of a book that that's what's good about dignity. But I think in the last, 5, 6, 10 years, there's been a lot more interest in the relationship between dignity and environment and human rights. I think it's kind of sort of got a growing attention, and I think there'll just be more so as we go forward.
Catherine?
Yeah, thanks, Stephen, and thanks, Dina. I think it's a very good question. I have maybe two sorts of guesses. The first one would be it's sort of the opposite of Dina's impression, is that nobody talks about or talked in the past about human dignity because everybody took it for granted. And it's there. I mean, you see it in the article 1. You don't need to read any other article, but it's there in full view for everybody to see. And nobody notices it because it seems to be so self-evident, so intuitive, so obvious, and we all agree on this. So let's move on and let's talk about equality, on which nobody agrees on, something like that. So there is that sort of misleading impression that maybe it's an easy concept and let's move on. Certainly lawyers, well, I'm told, common law lawyers in particular, they don't like conceptual stuff. Lawyers like practical, technical, clear. And so that might have been another hurdle, although lawyers have been very good at using human dignity in all sorts of ways. So there's lots of misconception, but there is still what I'm seeing at the EU level. Dignity is almost invisible at the EU level, despite being the first value under Article 2. And again here, you don't need to read the whole Lisbon Treaty. You only need to read 2 articles, and of the second article, you need to read the first 2 words. So it's a question of, for me as a teacher as well, and as a lawyer, of educating lawyers to see human dignity when it is in the law, and then it's another question about understanding it and all of that. So there is that dimension there, and so in fact I have three points. So the second point is that maybe it has to do as well with the fact that on the dignity front we were more or less all right. I'm saying that very, very cautiously, with the white wealthy Westerner lawyers, and so we didn't have that need for this tool, and that perhaps climate change is triggering human dignity, because it makes even the wealthy Westerner people think about it. Dignity was propelled as well on the legal scene, a discussion with bioethics question. What is humanity? What do we do with human cells? And this was big questions that we couldn't face with the other tools that we have in our legal toolkit. But I suspect, and that's a guess, and I don't know how I would test that it has to do with a very strong objection or reluctance to the full use of dignity. What is the full use of dignity? Is accepted that people want to take control over their life. They want to shape their destiny, and they want to do it against the belief that we cannot do it. So it's the idea of hope. Can we do something about climate change? Yes, we hope so. Let's do something about it. Can we go against certain taboo or predetermined sense of what we should be? So it's the whole secularization dimension. I think dignity is very much the way I see it, a secular concept, but going against centuries of you are born to do this, and this is decided for you and before you, and that will be like this. And now it's perhaps not so much God telling us how we should be, but other people are telling us, and other people don't want dignity to be used to resist those very strong impositions of what it is to be a woman or an indigenous person living in a certain way, what is a proper way of life, and all of that. So we are facing very strong reluctance and resistance in terms of, against empowering people to exercise their full humanity in all the ways we've been discussing. These are my three guesses and answers to your question. Thank you.
Marcus, did you?
Yeah, perhaps one thing to add. So it's interesting that in the first decades of the human rights endeavor, human dignity was not really discussed. Yeah, and when it was discussed later, it was, as Catherine mentioned, primarily bioethics. Yeah, and the kind of discussions had mostly to do with categorical prohibitions. So embryos, euthanasia, brain death, organ transplantation. So it's always about. So if the embryo has human dignity, you cannot do what, and if euthanasia, it's about all or nothing, or it's about genocide, then it's forbidden totally. So human dignity had always something to do with bringing human rights to a level where everything is forbidden, and that the Catholic Church came into the picture. Or have a look to the bioethics book of the President's Council for Bioethics in the early 2000s. That are the kinds of topic discussed. So the Bush administration, yeah, there were these kind of topics on the table, and these debates are from a kind that you don't see any way to deal with climate change in these terms, yeah, because climate change has to do it in terms of how do we change economy, how we it's about weighing things permanently. So you cannot forbid categorical, but you have to to think in much more complex terms. And so in the perspective of lawyers, that is, human dignity was difficult to handle. And I mean, I'm a German from origin. So in Germany, human dignity was in the first paragraph of the Constitution. And every lawyer said, if human dignity comes in the picture, it becomes incredibly complicated. Yeah. So try to avoid it as long as possible. That was, yeah. And I can remember that I once tried a research application in Germany with human dignity and climate change. It was hopeless. So these lawyers were not able to deal with that in the first instance. And I think that's perhaps changing, since we have only in the last 20 years a really vibrant human dignity discourse, and which is not only informed by German or American law, but it's an entire huge diversity of legal tradition which now plays a role. So suddenly the picture is much more complicated, and people understand there are much more traditions involved than we thought before, and so the picture now is much more open. And we have to see that the human rights regime is contested, which it wasn't 30 years ago. So that means some people think perhaps human dignity will help us out of these deadlocks in traditional human rights debates. So perhaps that are some of the reasons.
Thank you so much. That's so insightful. Thank you. Thank you very much indeed.
Yeah, I just wanted to thank you all for your really thoughtful answers to these very difficult questions. And also just thank you for your interventions today. They've been very, very thoughtful. And I think they really set the stage for some really good conversations that we're going to be continuing to have over the next couple of days as we start the program again tomorrow. So I just want to thank you all for your time. I'm sorry that you can't see the audience reaction, but I'm sure everybody is clapping for you. Stephen, would you like to close us out for the day?
Yes, I can do. Yes, thank you from me, and on behalf of the law school at Essex and the Human Rights Centre, I just want to say a massive thank you to each of the panelists for such excellent, fascinating, insightful and thought-provoking presentations. Thank you very much to Erin for chairing and also for bringing this panel together and making this panel happen. Thank you so much to you. And we have more sessions tomorrow. So please do join us for further sessions tomorrow if you're able to. And thank you very much for joining us. So
thank you.
Thank you.
We'll end there.